Good morning, viewers. This is episode 5 of the Slarskey LLC video series on specialty finance and litigation funding. In this series, we explore hot topics in legal funding and related asset classes. Today's episode focuses on insurance, the hot topic of insurance and legal funding. I'm Evan Freed. I'm a partner at Slarskey LLC. We are a New York-based litigation boutique. I've had a footprint in the litigation finance space for over 15 years. Among other areas of dispute resolution, we represent clients in an array of investment disputes, legal ethical disputes, and very often those issues touch on litigation finance. Our guests today are two titans of the litigation insurance market. We have Nicole Silver here from Ignite and Mike Perich from Lockton. If each of you can give the viewers a brief overview of your backgrounds and your practice.
You want to go first, Michael?
Sure. Thanks for having us, Evan. We really appreciate it. Nice to be on the podcast. Joined Lockton about 3 years ago, where I lead our litigation insurance group. Prior to joining Lockton, I was both a litigation funder and a litigation funding broker, a litigation funder at Gerchen Keller Capital and Burford Capital, and a litigation funding broker at Westfleet Advisors. I was also a policyholder lawyer in there for a spell. So very familiar with all sides of litigation, finance, trade, and the insurance world too. Been recognized as one of the top 100 global strategists in litigation funding for a couple of years now, and recognized by IAM as well for IP monetization strategy.
All right. Well, I can attest to the fact that he is one of the top brokers with whom we work. So it's always a pleasure to work with him. My name is Nicole Silver. I'm more new to the insurance industry. I joined Ignite back in November, and we've really been going in the United States since about January. Ignite itself as a company was founded in the UK. It's been going for longer, almost close to 3 years over there. Before I joined Ignite, I was at a litigation finance company called Validity Finance. And before that, I was a practicing lawyer for 19 years. So I worked at Winston, and then I was over at Greenberg Traurig, co-heading their international arbitration group. So that's my resume in a nutshell.
Awesome. Thanks, guys. So it looks like we got Nicole being the insurer, Mike being the insurance broker. We're looking to touch all aspects of the market today. But I guess the common thread of all of us, if we've all spent time in the litigation finance market, which has been percolating in the U.S. for well over a decade at this point. Walk us through from the insurance perspective how we evolved from litigation finance into this morass of litigation insurance. What are some of the problems that led to where we are today?
So, Nicole, do you want to kind of talk about how Ignite's genesis came about, and then I can address kind of the broader how this came out of the rep and warranty market here in the U.S. and kind of the combination of the two?
Sure. Well, Ignite started in the UK. Really what they were doing was a lot of insuring of single cases, wraps, ATE in particular, and then they have a schemes business as well. But I think how Ignite evolved was that in the UK, as they were doing a lot of this ATE insurance, which is after the event, for those who don't know, they began to do it more and more and more. And it seemed like the next phase was really to do wraps. And so they came across the pond and started Ignite in the US doing wraps. I don't know if that helps, but.
Yeah, and I think this is a really interesting kind of confluence of two markets coming together. So we have Nicole's group that is founded in the ATE business in the UK, and a lot of veterans there that have been doing it for a lot of time. So in the UK, insurers have been comfortable for quite some time playing on the plaintiff side of the V, and the reason why is because they have that mandatory fee shift, and there's after the event insurance that has to come through with that. After the event insurance, as Nicole said, pretty binary in nature. So using a portfolio construct, you're able to bring the cost down and do a more wrap. In the US, this came out a little differently from this point, and it came through the reps and warranty markets here in the United States. And they're not necessarily the same offerings, but they are litigation insurance. So in the reps and warranty context, a lot of times you had an M&A transaction, and it was getting held up by a disagreement over how much a pending lawsuit might be worth, what the exposure from that lawsuit would be. So let's say company A is buying company B, and company B, the seller is embroiled in a piece of litigation against someone in the patent space. And as we know, sometimes folks will file patent lawsuits and they will claim very high damages, and in reality, the damages aren't that high. But you need to be a specialist in order to understand the difference between what damages are real and what damages might be inflated at that point. So the buyer, when looking at the company, would say, wow, this lawsuit's claiming $100 million in damages. That's a lot. You, seller, should be bearing the risk. And the seller's thinking to themselves, no, we know this lawsuit's entirely frivolous, or not frivolous, but we know it's not worth anywhere near 100 million. Maybe it's worth 10 million and the best case scenario. So the reps and warranty markets evolved this product called adverse judgment insurance that was really intended to bridge that gap. So the seller would bear the first $10 million in risk, and the insurance markets would bear the next $90 million in risk. And from that product came the genesis of another product called judgment preservation insurance, which is ensuring that a judgment isn't going to be overturned on appeal, or a portion of the judgment's not going to be overturned on appeal. And then into these more specific contingent opportunities where really we could start to get creative with legal assets and legal liabilities, and how to structure the appropriate insurance solution around them. You add in now that there is folks like Ignite here who came across from the UK doing funder wraps, and we have this kind of renaissance of legal insurance in the United States that is going through, I think, some growing pains in some ways, and learning how best to structure these deals, but definitely something that brokers have invested a lot of time and effort into building their teams, and insurers have as well. I think it's a really cool product, and I'm excited to see what happens in the next decade.
Yeah, so I mean, I guess it makes sense why the insurers would go into this, and we'll talk about this more. It's a logical outgrowth of an existing skill set, and something that insurers are obviously able to underwrite. How about the quote unquote sell side, whether it be claimants or law firms or funders? What was missing from the litigation finance market that the litigation insurance market really could solve?
You want me to go?
Go ahead, Nicole.
Okay. Well, I think like this is more of an economic solve in many respects, because the rationing of capital across a lot of funders has resulted in some difficulty for law firms and companies that are seeking to obtain financing, especially when we're talking about scale. And this is particularly so because today the cost of litigation is just increasing and increasing and increasing. And so I think that there's a need, and insurance has come in to fill this gap for innovative financial strategies to really manage legal costs effectively. And insurance can definitely help by offering creative and more economic financial solutions for law firms and for investors and even funders. I would also add that with the presence of insurance, there can be almost zero downside risk to investors. And I guess my only point here is that adding insurance to an already existing litigation finance product means that more deals can get done, more investment companies or funds will be able to and will want to enter this market.
Yeah, I mean, we had Ben Blum from FlexPoint on a couple of weeks ago, and from the credit investors' perspective, he was saying, look, this can lower the cost. We're interested in this insurance stuff because it can lower the cost of capital, but it also can make an otherwise clunky product look a little bit more like a credit product. Would you guys, from the insurer's perspective, agree with that? Are you finding funders and law firms, kind of craving that?
I would say yeah. And there's a couple things I just want to add to what Nicole was saying. I think the most important thing is the bar that we're talking for investments and insurability is still incredibly high. So this is not like, Nicole's a very smart person. She obviously knows what she's doing from an underwriting standpoint. This goes for the other markets out there. But this is not something like they're going to see a lawsuit that as a funder you would say, no, there's no chance we would fund this, and say, yeah, we'll insure that. There's just a slightly different, viewpoint between the two when it comes down to, what necessarily claim damages have to be. A funder might be looking for a really high damages multiple in order to align all incentives, whereas the insurers are more caring about downside protection, i.e. not losing principal. So they're not as concerned at that point. I think there is still a lot of underwriting that goes into that because you're looking at settlement dynamics, because ultimately what these products are intended to do is to make a more efficient litigation process and make a more efficient resolution at all. So if we're using insurance to bring down the cost in some instances of litigation funding capital, you could see everyone kind of acting, there's not as much of the pie that's going to be taken up by a third party at that point. And because there's not as much pie that's being taken up by a third party, really we're talking about more efficient outcomes, which I think is a net good. The other thing that I kind of wanted to say is sometimes law firms will just insure their portfolios on their own because they don't necessarily need the capital. And I think that's a really other important point. And then the third is exactly right, Evan, that you were pointing to, just the ability to make this look a bit more like a credit investment ultimately is helpful. And with the rising cost of litigation, as Nicole was pointing to before, a litigation funder looks at a $10 million or $20 million investment, and could be a very meaningful portion of its fund. Let's say you have a $200 million fund, a $20 million commitment is 10% of your fund amount. With a credit investor, that's not as big of a check to write. It's still a large check, but not as big of a check to write. Right. So insurance can help those players come in, and it could also help litigation funders, overcome concentration limits. I will say litigation funders, when I talk to them, find it to be interesting more for the risk management element in terms of like fund management than they do actually risk transfer. Because if they needed insurance to do the case, then they wouldn't want to invest in the case itself. And that goes the same with credit investors. And that goes the same with law firms taking cases on contingency. Everyone's really aligned at that point in making sure that they're representing their client as best they can.
Got it. So, I mean, Nicole, you touched on this earlier, you used the word scale. Insurers like to cut big checks, right? Or they like to be exposed to big opportunities because it's got to be worth their while. How are the insurers? I don't think you're saying, hey, we're insuring a bunch of little cases. How are the insurers getting that scale that they need, and finding, the right way to tap into, large opportunities?
Well, I almost think that question is better answered by Michael, since he's the person who brings us these large packages and wraps. But just before I pass the baton back to Michael, I just wanted to echo something that he had said, which is, no one here is in the business of helping to facilitate frivolous lawsuits. This is not even a risk transfer tool. It's really a means by which to facilitate better and cheaper and more economic and efficient financing. So, whether it's a funder or an insurer, it is absolutely not about bringing more or frivolous lawsuits. So just wanted to
I just think it's a really important thing to emphasize, and this kind of goes out to like the screen process. So Evan, I guess there's two ways that this happens in packaging. So the law of insurance works with a lot of opportunities with a lot of diversification, and certain of the insurance products we were talking about before have the ability to have a lot of diversification if it's structured right, but there needs to be a more flow that comes through there, and we can get into that at a later date. But in terms of the wrap products that are present, it's looking at various sizes. So a litigate like we were all in litigation funding for quite some time. We all know like there's a lot more 10, 5, 10, $20 million, opportunities out there than there are $100+ million opportunities, especially when we're carving off. And I think it's important to emphasize this, things that are like personal injury style lawsuits, mass tort lawsuits, things like that are not going to be things that are insurable. So when we look at the commercial litigation market, there's not everyone's going to be out there looking for a couple $100 million or $100 million. Most people are going to be looking for at most 30, 40, 50 million when we're talking about kind of a program structure across a portfolio of cases. Sometimes it'll be less. It just really depends on the law firm and where the firm is located. So, a firm that's located in New York, probably going to need a bigger insurance program than a firm that's located in Chicago, where the rates are less than you would have in New York. So really it's coming down to more diversification at that point, diversification of claim type, and really partnering up with the right law firms and the right funders and the right corporations that are looking for exploring these products as well to come with this type of, solution that's meant to better and make litigation more efficient and help with more efficient resolutions off the top.
I mean, when litigation finance came to the U.S., there were questions about, is this a product that really goes to, the gunslinging lawyers, the plaintiff's bar, or is this applicable to, the Am Law 200, the quote unquote big law firms? It's, big law firms are all about risk management. So it took them a second to understand why litigation finance. This seems like, have a very broad application to the real traditional big law firms who are, looking to take risk, looking to be entrepreneurial, but are, number one focused on, consistency and risk management. Are you guys seeing that, the Am Law 200 is beginning to think about these, with protection or, insurance products that might be available to the to the big firms?
I mean, I think the answer to that is yes. And I am sure that they will accept it and start using it much more quickly than they jumped on the litigation finance bandwagon. I mean, I remember back in something like 2010 or 2013, it was so hard to convince big law to accept and use and utilize litigation finance. And now they all do it. So I think the door has been opened and this will come much more quickly and easily for big law firms. And they should use it because it's a great product.
I'd echo that. It's a much different conversation to have because there is this base understanding of litigation funding. And litigation insurance is in a lot of ways just kind of the litigation insurance, I should say, not all, but litigation insurance that, Ignite works on in particular, in a lot of ways is complementary or can be a replacement for various firms in the litigation funding standpoint. Because it's really just meant as a cash flow management tool, right? You now have been able to insure a portion of your work in progress, not all. I mean, there has to be risk transfer, there has to be alignment of incentives and all that, but you're able to insure a portion of your of your work in progress and have that budgeting over time, knowing exactly, at this point, I will get paid this amount at the end of a set period of time, which is something you aren't able to do with a normal contingency fee arrangement. I mean, I remember when I was a practicing lawyer taking things on contingency, how hard it was for us to predict what was going to happen one year to the next. Because, I mean, you don't know if the court's going to sit on a motion for summary judgment for a year or two, right? Or you don't know, post-trial motions you want at trial. You don't know if they're going to wait 6 months to issue an order or a year. And on appeal, you have no idea how long the appellate court's going to take. So this kind of provides that backstop certainty.